Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. Today I wanted to address three of the most common misconceptions or myths that I hear when it comes to probate in the state of Florida. And one of them is that probate is so expensive that there won't be much left for the heirs. And that simply is not necessarily true. Many times the cost of probating an estate is just a percentage of the estate. It's usually a very small percentage. When people find that probate becomes expensive, generally speaking, is when there involves probate litigation, meaning there is a dispute over assets or claims from creditors that there's a dispute over whether that person is an appropriate creditor and their claim is appropriate. When there's litigation involved, that is when probate becomes expensive. But generally speaking, the majority of people pass away, their assets are probated, and it's not at a great expense. It is at a small percentage comparison to the estate itself. And should the estate be a small estate and not, there's a mechanism called the summary administration here in the state of Florida, which also would make sure that the estate can be probated smoothly and efficiently at a low cost. So that's one of the myths that I hear frequently. Another misconception that I hear frequently is that most debts are wiped out at death, right? Like when you die, your debts are wiped out. And that's not true either. The decedent's creditors can make a claim. Should the claim not be made timely, those debts would be wiped out. Creditors, there's a 2-year window. So should the decedent you don't probate their estate for over 2 years, you can go through the summary administration, which would it's a smoother process and it's a shorter process because of the creditor period has lapsed. But generally speaking, I do know that many times creditors will encourage family members to pay the decedent's debts, but you're not obligated to. That doesn't mean it's not because the debt has been wiped out because they passed away. It means because the debt is not yours. It is the decedent's debt, and therefore it is an obligation of the estate. So should the estate not have enough funds to pay all the creditors, certainly then some of the debts would be wiped out. So should the person pass away and they have tremendous amounts of debt, more so than they have assets, clearly all the creditors are not going to get paid, and therefore those debts would be wiped out. However, the heirs aren't also there won't be any distribution for the heirs either, because the creditors would get paid from what small amounts were in the probate estate. So for that reason, why it is good that relatives not pay the decedent's obligations. They are obligations of the estate, and the creditors can make claims to the estate through the probate process. So you don't need to pay for your loved ones' bills after they pass away. However, the estate would be obligated to handle that as part of the wrap-up. Another common misconception that I hear frequently is that the oldest child would be named the personal representative. There's just like some sort of presumption in many families that the oldest child would be named the personal representative, and that's not always true either. If there's a will, whoever was named in the will be the personal representative, no matter if they are the oldest child or the youngest child, the middle child, or a nephew that the decedent loved. Whoever they picked, that would be, as long as they qualify, that would be the personal representative. And if there is no preference named, the Florida statutes has a priority mechanism where the surviving spouse has first priority. Second priority would be the person that all of the heirs agree upon. And third priority would be the next in-line heir, so the one with the greatest degree of relationship. And if there's more than one children generally are equal, child, so you'd have 2 children. The court would then decide who has who's most appropriate to serve, and it has nothing to really to do with birth order. So I hope that those I've cleared up some common misconceptions with regards to probates. If this content has been helpful to you, I ask that you like and share. As always, if you have specific inquiries about a case that you may have in mind, I encourage you to reach out to a Florida probate attorney. Thank you for joining me.